So the tragic events of Marikana are back in the spotlight as miners prepare to face off with Sibanye-Stillwater mine and President Cyril Ramaphosa over the Marikana massacre. As you know, the massacre claimed 34 lives on the 16th of August in 2012. The court case is currently being held virtually. Let's take you there now live.
The ground which appears in our heads of argument at paragraphs 45 to 49, and that begins at page 006-23. Now, some of what I say will overlap slightly with one of the earlier grounds which was argued by my learned friend, Mr. Trengo, but nevertheless, let me deal with it in any event. So the fifth ground really concerns the origins of the duty of care, which are said to rest on Mr. Ramaphosa. And you will know that in the particulars of claim, Mr. Ramaphosa is said to bear various duties. I beg your pardon, I'm just shifting my screen for a moment. He's said to bear various duties on the basis of various capacities. So it is pleaded that he was a non-executive director of Lonmin. He was the chair of Lonmin's Transformation Committee. He was a shareholder and chair of Shanduka, which was a minority shareholder in Lonmin. And he was a member of the NEC of the African National Congress. That's at paragraphs 5.1 to 5.5 of the particulars of claim. And then in the next paragraph, paragraph 6.1 of the particulars of claim, which appears on page 001-9, it is said that the first defendant is sued herein, both in his personal capacity and or as a director of Lonmin, as indicated in the preceding paragraph, and in pursuit of his personal interests and those of Lonmin. Now, the difficulty that is raised by the fifth ground of exception is this. The allegation that Mr. Ramaphosa bears these duties as a consequence of being a director of Lonmin is simply bad as a matter of law. And that is for the reason that is given by my learned leader, which is that a director owes duties to a company, but not duties to even individual shareholders, much less to individual employees of the company. And that is made clear by the judgment of your lordship's brother, Unterhalter J, in the De Bruyn matter, which we have cited at paragraph footnote 47 of our heads. And indeed, we've quoted it at 006-24 of our heads. De Bruyn, you will recall, was a class action arising from the Steinhoff debacle. And there was a class action, and the question was it tenable as a matter of law? And Justice Unterhalter explained, a case can be pleaded that the conduct of the Steinhoff directors is in breach of the director's fiduciary duties. But in accordance with the standard account of directors' fiduciary duties, those duties are owed to the company. Any harm suffered as a result of the breach is actionable by the company to whom the duties are owed. The breach may also cause harm to shareholders, and indeed potentially to other classes of persons, creditors, employees, suppliers, and customers. The harm does not establish that the duty is owed to all persons who suffer harm. So a very explicit and clear statement of our law, which is that a director of a company does not owe duties to individual employees, and therefore that on this basis alone, the ground of exception should be upheld. Now, our learned friends in their heads of argument seek to contend that this is not a permissible ground of exception because it is raised to what they characterize as an alternative claim. I'm not sure I read the particulars in the same way, but let me assume for a moment that the ground is an alternative claim. And they say it's flagrantly impermissible to raise a ground of exception to an alternative claim. That is not correct. There are multiple authorities which make clear that one can do so. And could I just give them to your lordship? Unfortunately, they were not heads. The first one is Dupré versus Bootsup Stores, 1978, volume 2 of the South African Law Reports, page 177, a decision of the Northern Cape Court at 181E to 182A. The second is Trustees Bus Industry Restructuring Fund